Hello, I'm Vince Davis. Today, we're discussing critical updates in California's trust and litigation landscape. The laws for 2024 and 2025 are shifting significantly, affecting how estates are handled and how we represent you. From probate bypasses to trust modifications, staying informed is essential for protecting your legacy. Let's dive into the first major change, Assembly Bill 2016 and its impact on primary residences. Starting April 1st, 2025, AB 2016 introduces a new way for middle-class families to bypass probate. It allows for the transfer of primary residences valued up to $750,000 without formal probate. Previously, the threshold for real property was much lower, making this a substantial shift in law. This expedited court process uses a petition to determine succession to real property. However, there are key limitations you must understand to qualify for this bypass. It only applies to deaths occurring on or after the April 2025 effective date. The law is strictly for primary residences. Vacation homes or rentals still face the old thresholds. The value is based on gross fair market value, meaning mortgages are not deducted from that $750K limit. New notice requirements are also in place to prevent fraud and ensure all heirs are informed. Experts suggest this may lead to more litigation, as more heirs will be formally notified of their rights. Next, let's talk about AB 565 and the concept of virtual representation in trusts. Effective July 2025, this law aligns California with the Uniform Trust Code regarding trust notices. Virtual representation allows one beneficiary to represent and bind another similarly situated person. This includes minors, unborn persons, or unknown heirs who have similar interests in the trust. In the past, these situations often required court-appointed guardians ad litem, causing delays. AB 565 aims to reduce these administrative costs and the need for frequent court intervention. It streamlines trust modifications and accountings, making the process more efficient for families. By allowing representation of similar interests, we can resolve trust matters more swiftly. This change is a welcome update to Probate Code Section 15804 for legal practitioners. It provides a clear framework for handling complex beneficiary situations without unnecessary red tape. A major judicial development occurred in 2024 with the Supreme Court ruling in Haggerty versus Thornton. This case resolved a long-standing split regarding how trusts can be legally modified. The question was whether trusters must follow the specific modification method in their document. The court held that the default statutory method remains available unless expressly excluded. This means assigned writing delivered to the trustee is often valid, even if not notarized. It provides vital protection for individuals who may amend their trusts without legal counsel present. Unless your trust document says its method is the exclusive one, the law protects your changes. This ruling brings much-needed clarity to trust litigation and the validity of amendments. It ensures that a person's final wishes are honored, even if procedural details were missed. We closely monitor these rulings to ensure your trust remains ironclad and enforceable. The State Bar of California has also introduced the Client Trust Account Protection Program, or CTAPPP. This program imposes aggressive new reporting and audit requirements on all attorneys. Starting in 2026, financial institutions will report trust account balances directly to the State Bar. These transparency measures are designed to prevent the misappropriation of client funds. Additionally, there are new procedural updates for litigators that affect your case timelines. Summary judgment deadlines have been lengthened, giving more time for thorough case preparation. Filings are now due 81 days before a hearing, providing a more deliberate pace for litigation. Electronic service requirements are also expanding, with a full mandate expected by July 2025. Child support enforcement in estates has also seen updates under AB 1521. Representatives must now notify the Director of Child Support Services of potential obligations. This creates a clear window for claims, providing certainty before an estate is closed. These procedural shifts are part of a broader effort to modernize and secure the legal process. Navigating these changes requires a deep understanding of both the law and the courtroom. Call us now at 888-888-6582. I'm Vince Davis, and we are all in this together. Let us help you protect what matters most with the latest legal strategies and experience.